Welcome back to this course on copyright and related rights law. In the previous session, we had started our discussion into understanding authors' special rights under Section 57 of the Indian Copyright Act. We had understood that these are independent of an author's right. In other words, it is over and beyond copyright under Section 14. We will continue our understanding into author's special rights in this session. The first point of discussion today is on the right of divulgation, which is provided to the author under the French IP Code. We must consider that divulgation effectively means to make information known. Isn't publication of a work making information known to the public? The right to divulgation then is of a different nature because this is a moral right, something that is having a deeper connection with the author. This is something which is applicable in situations where the first ownership might vest with someone else. There has been an assignment, and in such cases as well, the right of divulgation has to be specifically provided by the author. A limitation that has been placed within this provision, as you can see, where the provision has been made subject to L 132/24, is in respect of audiovisual works. The encumbrance that such a right of divulgation could have on the producer to freely distribute and freely commercialize the cinematograph film, which is effectively a composite work, is something that has been taken away by this provision. But in all other respects, the right to divulgation exists with respect to the author. Still another moral right that we find under the French IP Code is the right to withdraw the work from the market. Let us take a look at this provision first. In Article L 121(4), the French IP Code states, notwithstanding assignment of his right of exploitation, the author shall enjoy a right to reconsider or of withdrawal even after publication of his work with respect to the assignee. However, he may only exercise that right on the condition that he indemnify the assignee beforehand for any prejudice the reconsideration or withdrawal may cause him. Let us understand that the risk of publication is something that is traditionally not something authors bear. Authors engage in a transaction of assignment with publishers, for example, if it's a book. The publisher then will release this book into the market, and in doing so will incur a significant investment. There is also a substantial risk that the publisher faces on account of a possible failure to meet a recovery of the investment that has been made with respect to such publication. Therefore, when publication occurs, there is a serious interest of the publisher in terms of an economic prejudice that will result to him. Therefore, what this provision is saying is that in acknowledging that the author has a right of withdrawal simply because he is the author of the work, and in response to the natural connection that the author has with the work, such a withdrawal should not lose sight of the interest of the publisher. And therefore, in cases of such withdrawal, if the author can indemnify the assignee, then this is an equitable position. But why would an author want to withdraw work at all? It could be because of a change of perspective in society. Perhaps the author himself is not in favor of the work for any kind of reason to be present in the market at that point of time. In any case, this is a question of personal opinion and something that the French IP Code does not restrict in any manner. The provision also says that if the author decides to have his work published after having exercised his right to reconsider or a withdrawal, he shall be required to offer his rights of exploitation in the first instance to the assignee he originally chose and under the conditions originally determined. The provision explains further that this assignee who had taken up publication of the author's work in a consideration of good faith, because the withdrawal was something which was completely at the option of the author. This is something which must be offered to that assignee first. Having taken a look at the right of divulgation and the right of withdrawal under the French IP Code, let us recall what we discussed under section 57. We discussed that the author has a right of attribution or the right to claim authorship of the work and the right against distortion, mutilation or modification which is prejudicial to his honor or reputation. In terms of the expanse of moral rights, or as they are called, author special rights, in India we find a restricted application of moral rights. In comparison, as we have seen, the French IP Code offers a more expansive consideration. Focusing on section 57 then, now we will take a look at two important cases that have arisen with respect to moral rights and that help us understand author special rights better with respect to India. The first case that we will discuss is this case of Amarnath Sehgal versus Union of India. The Delhi High Court was considering a case involving a famous artist by the name of Amarnath Sehgal, who had created a mural for the government of India to be placed in an important government building, where this particular mural was taken down without his authorization and relegated to a storeroom to catch dust. Some parts of the mural even having gone missing. The artist approached the court to find a solution under section 57. Honorable Justice Pradeep Nandajo, who has authored this judgment, provides in clear language of the importance of moral rights and how it is to be understood with respect to section 57. Honorable Justice stated, the plaintiff who believes that there can be no beauty without a soul has brought the present action hoping that the soul is given its due place and recognition in the history of law. He says, moral rights of the author are the soul of his work. The author has a right to preserve, protect, and nurture his creations through his moral rights. When we had discussed how the French IP Code explains moral rights, connects it to the person, similarly, Honorable Justice Pradeep Nandajo also highlights this inherent connection, this natural connection that a work has to the author. And according to him, it forms the soul of the work. Clearly, because these are the soul of the work, the author would no doubt be deeply hurt if any action which is prejudicial to such work is done by another person. Therefore, as the judge explains, the author has a right to preserve, protect, and nurture his creations. And this can be done through section 57. To look at the nature of the mural, the judge explained that there was research and untiring work spanning over half a decade in creating that mural. It was simply taken down without the permission or authorization of the author. It was consigned to a storeroom where it was catching dust. Is this kind of treatment of a work something that the author of a work should be fine with, even if he is not the owner of such a work? After all, once an artist has parted with the work, as was the case herein, it was the government which was the owner of the work. There was no copyright then that was subsisting with the artist. But we have understood that section 57 is independent of copyright, and therefore the following reliefs, please pay attention, were sought by the artist. The artist claimed to restrain the defendants from further distorting, mutilating, or damaging his mural, to pay damages towards compensation for humiliation, injury, insult, and loss of plaintiff's reputation, and to return the mural to the plaintiff. You can see in the reliefs that are asked by the plaintiff the feeling of hurt in the treatment of his work. This demonstrates in clear terms what Honorable Justice has explained forms the soul of his work, how the artist is looking to nurture the work that he had so painstakingly made. The court looks at explaining what are the types of moral rights. As we have already understood these rights, it bears relevance to refer to how the court has looked at these rights. The court says, when an author creates a work of art or a literary work, it is possible to conceive of many rights which may flow. The first and foremost right which comes to one's mind is the paternity right in the work, that is, the right to have his name on the work. It may also be called the identification right or attribution right. This is the right which we had discussed as the right to claim authorship. The court further says, the second right which one thinks of is the right to disseminate his work, that is, the divulgation or dissemination right. It would embrace the economic right to sell the work for valuable consideration. We had discussed that the right to divulgation is not something which is provided within section 57. Linked to the paternity right, a third right, being the right to maintain purity in the work, can be thought of. There can be no purity without integrity. It may be a matter of opinion, but certainly treatment of work which is derogatory to the reputation of the author or in some way degrades the work as conceived by the author can be objected to by the author. This would be the moral right of integrity. We have seen that the moral right of integrity is provided under section 57. Will not the action of the government in this particular scenario, where without the authorization of the author it has been pulled down, relegated to the storeroom, fall within the scope of section 57? and specifically the right of integrity? It would. The court further says, lastly, one can conceive of a right to withdraw from publication one's work if author feels that, due to passage of time and changed opinion, it is advisable to withdraw the work. This would be the author's right to retraction. This right is also something which is not found under Section 57. One important consideration that we must keep in mind when we look at the right of integrity, as the court explains, is that the question of a violation of the right of integrity is seen from the conception of the author. It is an objection made by the author, and therefore the perception that will be considered must be given weight is the author's perception. With respect to the limitation that has been crafted under Section 57, limiting right of integrity to honor or reputation, the court explains, had such a limitation not been made, it would lead to certain anomalous consequences. Not just that, in the Berne Convention, under Article 6 bis, in which we find moral rights, Berne Convention, as we have seen in earlier sessions also, is an international instrument that provides for the framework of protection for copyright, to which India is a party. In Article 6 bis makes this connection between the right of integrity and honor or reputation of the artist. If in fact India had retained the original provision under Section 57, in which any distortion, any modification, any mutilation could be brought in, then it would also be an expansive consideration beyond what was provided under Article 6 bis of the Berne Convention. The relief then that was granted by the court was that there was a direction to return to the plaintiff remnants of the mural, a declaration that all rights in the mural shall vest with the author and not with the defendants, the absolute right with the author to recreate the mural and to sell it, and damages. Therefore, in upholding the moral rights of the author under Section 57, the Honorable Delhi High Court explained in very clear terms in what manner should such a moral right be considered. Let us look at another case which looks at author special rights under Section 57. You would recall that we have discussed this case in an earlier session in which we discussed architectural works. Rewal versus Union of India is an important case in which the court considered the question of whether demolition of a building is something that can be brought within the ambit of Section 57. Let us understand this question. The right of integrity of the author is a right against, you must all be now saying, distortion, mutilation, modification of the work prejudicial to his honor or reputation. Can such distortion, mutilation, or modification include demolition of a building? We had discussed in our earlier session, where we had discussed this particular case, that the owner of a building has a different interest in the building than the architect who has an interest through copyright. We had understood the possible conflict that this will bring between the statute provided Copyright Act and a constitutional right of the right to property. Let us consider how the court is looking at this issue. The court is saying the words distortion, mutilation, and modification have to be understood as making the work look, appear, be seen as something different from what the author had created and in which creation the honor and reputation of the author vests. The principle is that the work should not be rendered imperfect, affecting the honor and reputation of the architect. Let us understand principally what the quote is saying. Is it not a question of perspective? When a work is perceived, if a modification has been made to a work, then if that modification is in fact seen as being different in such a way as to be prejudicial to the honor reputation of the artist, then yes, there is a violation of the right of integrity. But this difference of perspective must be visible. It must be perceptible. Is it possible to consider something as being violative of the right of integrity when it cannot be perceived? After all, if a building has been demolished, what is there for any person to see? The quote says, however, it is explained that failure to display a work is not infringement of rights conferred by Section 57. In recognition or acceptance of that what cannot be viewed, seen, heard, or felt cannot be imperfect and cannot affect the honor or reputation of the author. We had seen in the earlier session when we had discussed the explanation to Section 57, Clause 1, it very clearly says that failure to display a work is not an infringement of copyright. The court uses this particular explanation to reason that this explanation has been brought in simply because of the consideration that if we cannot view the work, then how is it that we can consider a perception? Accordingly, the court then explains that there is a difference between the work itself and one of the embodiments of the work. While distorting or mutilation or modification of one of the embodiments of the work renders the work imperfect, prejudicing the honor or reputation of the author, destruction of the work in its entirety, that is, making it disappear, cannot be prejudicial to the honor or reputation of the author. After all, no imperfections can be found in what cannot be seen, heard, or felt. Finally, the court says, the implementation or transformation into a building of the work of architecture is governed by other laws, such as the laws relating to town planning, building bylaws, environmental laws, and laws protecting the rights of owners of adjoining buildings. It is thus not necessary that the building or the structure constructed is always a true reflection of the drawings or the designs authored by the architect. The requirements of urban planning outweigh the moral rights of an architect. Similarly, technical reasons to modify the building, economic reasons justifying modifications to the building, and the necessity to obtain an authorization to build all prevail over moral rights. According to the judge, his research has disclosed that no jurisdiction in the world is prohibiting demolition of a building or structure constructed in accordance with architectural drawings or plans. In summarizing, we can then say that in connecting our earlier discussion on architectural works, the interest of a builder on the building, the owner of the building, is completely different from the interest of the architect. Such construction of the building is regulated by other laws, and in terms of such an interest and such a conflict, we must understand that moral rights cannot be sustained, especially in a scenario where there is demolition of such building. Having understood economic rights under Section 14 and moral rights under Section 57, we will now start with our discussion into exceptions to copyright. And in the next session, we will take a look at fair use. Thank you for joining me. See you all in the next session. Thank you.